Hello, good day guys. So today I'm doing a pre-recorded video. I hope you're all doing great. So yesterday we started talking about what happens when you have a pending U.S. immigration application and life happens. So when you grow older, or you get married, or you get divorced, or somebody dies, what happens. All right, guys, so let's do a brief recap of yesterday's point, and then we can jump into today's video. I'm sorry. So the first thing we spoke about yesterday was when there's a life change. So when the petitioner naturalizes. So as we stated yesterday, there's a difference between the the immediate relative category and then the preference immigrant category. Immediate relatives are the spouses, parents, and children under 21 of U.S. citizens. No visa quotas for them. Visas always available. But the preference categories are the F1, F2A, F2B, F3, F4. So a brief recap: the F1 is the unmarried sons and daughters, 21 years older, 21 years and older of U.S. citizens. Then we have the second preference, which is the F2A. Those are the spouses and children of green card holders, okay? Those are lawful permanent residents. Then we have F2B, that's the second preference. Those are unmarried sons and daughters, 21 years and older, of lawful permanent residents. Those are also green card holders. LPRs are green card holders. Then we have the third preference. So the third preference category includes the married sons and daughters of U.S. citizens. Doesn't matter their age. So you can be 19 years old and you are a child, or you can be 50 years old and you can be a married son or daughter of a U.S. citizen. Those are in the F3. Once you are married and you are the offspring of a U.S. citizen, you're in the third preference, the F3 category. Then we have the fourth preference, which is the brothers and sisters of U.S. citizens. Of course, the U.S. citizens have to be 21 years and older to be able to petition for their siblings. Okay, guys, I'm sorry. So we spoke about the first one. When the petitioner naturalizes, it means that a green card holder becomes a citizen. And when you become a citizen, and let's say you're a citizen and you filed for your spouse, as a green card holder filing for your spouse, you are in the F2A category, okay? But when you naturalize, your petition converts from an F2A to an IR, immediate relative. If you file as a green card holder for your child and you naturalize, also moves from F2A to immediate relative, okay? Of course, your child is under 21 years or older. Then if there's a life change where the beneficiary gets married, when the U.S. citizen, you as a U.S. citizen, you file for your unmarried child. Your unmarried child would be, of course, in the immediate relative category because they are under 21 years old and they are unmarried. But what happens if, okay, let's say John is a U.S. citizen. He has a child who's let's say 19 years old. The child is in a foreign-based country. Let's say he's in Ghana or Korea or India, or let's say Ghana or Nigeria. Let's simply say that. And the child is 19 years old. John has filed for his child, who is, let's say, Jonathan. Jonathan is an immediate relative because he's 19 years old. He's a child of John and he's under 21. So he's an immediate relative. So there's no waste time. If Jonathan goes ahead and goes to get married, he's still a child of a U.S. citizen because he's under 21 years old. His petition will now convert from IR, immediate relative, to the F1. Because remember, his petition will now convert from IR to F3. F3 are the married sons and daughters of U.S. citizens, okay? Married sons and daughters, it can be a married child. You are 19 years old. Some countries allow people who are above 18 years old to get married. So the petition will convert from IR to F3 all the way. And let's say also let's move to the green card holder. So if the F1, let me see. Okay, so a U.S. citizen petitions for an adult or daughter. Okay, so here, if a U.S. citizen petitions for an adult son or daughter, that means that the adult son or daughter category is F1. Adult son or daughter who is not married, of course, is F1. So F1 houses the category of unmarried sons and daughters of U.S. citizens. So if John petitions for his unmarried son or daughter who is 21 years and older, so John has a daughter known as Josephine, who is 25 years old. At the time of the filing petition, Josephine lives in Ghana. Josephine was not married, and Josephine was an F1 preference category. John has filed for her. Josephine meets the love of her life, gets married. Josephine's petition, which was F1, immediately converts to F3, which is the married sons and daughters of U.S. citizens. Okay, so that's the life change that happens, and it changes the category of of the visa weight or the preference immigrant category. Let's move to the let's talk about a couple more and then we move on. So when there's a life change, such as the beneficiary divorces, when the U.S. citizen files for a married son or daughter, remember the married son or daughter would be in F3. So let's say John has filed for Josephine, who's in F3 because she's now married. John is a U.S. citizen. He's filed for his daughter Josephine, who's F3, who's married. Josephine then divorces. As soon as Josephine divorces, what will happen is that the beneficiary, who's Josephine, her petition will convert from F3 to immediate relative because now she's single, she's unmarried, and it will convert from F3 to IR, immediate relative, of course, because hold on, from F3, because Josephine is 25 years old, her petition would move from F3 to F1 because F1 is unmarried sons or daughters over 21 years old of U.S. citizens. But remember, we spoke about Jonathan, who's 19 years old. If Jonathan divorces, Jonathan is the one that moves from F3 to IR because he's still under 21 years old. Okay, so depending on their ages, that's what happens when there's a divorce. And if there's a life change where the child beneficiary turns 21, a child beneficiary or derivative beneficiary, sometimes you may age out of a child status by turning 21. But under the Child Status Protection Act, there are some beneficiaries who may still remain in the child category even after turning 21. We'll go into the Child Status Protection Act later because there are some complexities. It depends on whether the child is in the F2A category or is an immediate relative. Sometimes the age will be adjusted or whatever. Those are more, we have to go into more detail there, but just know that sometimes the child will, even though they've aged out, because the petition was filed when they were under 21 years old, the category will not change. It would be deemed as though they're still under 21 years old. So let's say John filed for Jonathan, who was 19 years old. It takes, let's say, 4 years for the petition to be approved, and Jonathan turns 22. Jonathan will still be in the IR category, immediate relative category, because he's under 21 years old. He's the child of a U.S. citizen, and the petition was filed by John when he was 19 years old. Okay, so that's what happens in that instance. And then when there's a life change where petitioner or the principal beneficiary dies, pretty much the death of a petitioner or a principal beneficiary may end the ability of the principal or derivative beneficiary to immigrate. Okay, so sometimes it depends. Of course, certain surviving relatives may qualify to continue to immigrate even after the death of a petitioner or principal beneficiary. So that just really depends on what's happening. I would like to actually talk about the numbers of visas. Maybe I can do that in another video because we've done 10 minutes already. So guys, I hope this was helpful. All of this just to say that be mindful of the steps you take when you have a pending immigration application. Make sure you consult with your licensed U.S. immigration attorney, because this can get very technical and quite tricky. So you want your attorney to review everything and make sure that you're doing the right thing and you are not jeopardizing your application in any way. Please call me if you need my help, 802-7800-564, and I will be happy to assist you. I represent clients all around the U.S. and I handle all types of U.S. immigration law matters. We bring legal service right to your doorstep, so don't worry if you're far away or whatever. All my information will be in the description box below. Also, don't forget to like, subscribe, share, comment on this video. I will see you again in the next one. Take care. Bye.